Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello and welcome to Our Curious Amalgam, the podcast from the Antitrust Law section of the American Bar Association. My name is Matthew Hall and the title of today's episode is What Should I Know About Nigeria, South Africa, Egypt and COMESA, Developments in Key African Regimes. We are recording this episode in person at the 2025 Antitrust Law Spring Meeting in Washington, D.C. I'm very pleased to be joined by John Oxenham and Nicolas Bremer. John is the managing partner of law firm Primerio, a Pan-African competition and antitrust law practice, and an active member of the Antitrust Law section. Nicolas is a partner with the regional law firm Bremer, where he heads the firm's antitrust and merger control and mergers and acquisitions teams. He oversees the firm's Riyadh and Cairo offices. John, welcome to the show.
Thank you, Matthew. Pleasure to be here.
Nicolas, welcome to the show.
Thanks. Pleasure to be here also.
So today we'll be discussing developments in merger control, antitrust enforcement, and related issues in the key African jurisdictions of Nigeria, South Africa, and Egypt. We'll also consider the COMESA regime. COMESA, as listeners will likely know, is the common market for Eastern and Southern Africa, which in a similar way to the EU has its own rules overlaying those of its 21 member countries. Egypt is a member of COMESA, but South Africa and Nigeria are not. So, John, we'll start with you, please, in relation to Nigeria. Could you just run us through what you see as the priorities of the competition law regulator in that country?
Thank you, Matthew. I think there's been a notable change in respect of enforcement across Africa, and that's largely as a result of the Nigerian authority really coming on stream. And the FCCPC, which has evolved not just to handle competition issues, but also consumer protection issues, has really been a catalytic change in respect of antitrust enforcement across Africa. So from a priorities and enforcement issue across the continent, and more particularly in relation to Nigeria, there's certainly been a number of welcome changes and welcome enhancements. Those have largely resulted in changes to the merger review processes. There have been a number of interventions and enforcement actions which have taken place in the jurisdiction itself. Now, for the listeners' benefit, Nigeria is, if not the largest economy in Africa, the second largest economy in Africa. And so what takes place in Nigeria has relevance. There's certainly been focus areas in relation to its enforcement activities. Those have been not too dissimilar to what's been taking place internationally. Big tech, the telecommunications sector, and to a large extent in relation to just general media houses. There have also been legislative changes and also a number of advocacy and capacity building developments within the authority itself. Within the telecommunications sector, there have been notable judgments which have been issued by the Nigerian high courts, and those have really affirmed the jurisdiction of the Nigerian FCCPC to target anti-competitive practices within that sector and resolve a relatively long-running dispute in respect of sectoral authority and jurisdiction. Equally, in the media and broadcasting sector, there have been quite notable developments in that regard. One resulted in not just a pure administrative sanction in respect of one of the largest digital services providers in the media space, that's MultiChoice, administrative penalties in respect to that entity, but equally a criminal charge against the CEO, which is somewhat unique, and that was for failure or lack of adherence in respect of the investigation which is being conducted by the authority itself. Now, similar to jurisdictions internationally, and there's somewhat of a trickle-down effect which occurs in a number of the African jurisdictions, but not something which hasn't occurred in Nigeria, is a focus on big tech and, as I say, in digital markets, as I said in the introductory comments. the authority has targeted that, and certainly in relation to its administrative prowess, has imposed probably some of the biggest headline-grabbing cases across the continent. That was more recently in 2024, a penalty imposed on the entity Meta, I should say. That fine was in respect of both consumer protection and competition issues. That was an investigation spanning approximately 3 years, and principally in relation to information, exposed information, consumer information on the WhatsApp personal data platform. I think probably one of the more notable developments, and one which to some extent put the authority on the map from an international perspective, was an investigation which was concluded in respect of British American Tobacco. And there were a number of sort of hallmark features in relation to that. There was raids on the entity itself. There was quite substantial searches conducted at the headquarters of that entity. But more importantly, there was a lot of, I suppose, jurisdictional dispute between the entity itself, British American Tobacco, and the Nigerian authority. What was noteworthy there is that I think the authority really sought to stamp its authority in relation to the competition landscape, and because of those jurisdictional challenges which had occurred, managed to succeed, and even went so far as to extract a consent order against British American Tobacco of $110 million, which was massive at that time. Now, these are US dollar-based figures, not Nigerian dollars. And so even in comparison to other comparable jurisdictions across the continent, these are not insignificant by any means. But what it does demonstrate is, at least from an enforcement perspective within the authority, significant attention is being paid to ultimately achieving success, and they have done so in relation to extracting significant administrative penalties on reputable companies, and based on sound investigative techniques and I think enforcement activities before the courts in Nigeria themselves. It's quite, I suppose, from a general approach, worrying to some extent that British American Tobacco case ultimately resulted in the demise of the previous chairman, Babatunde Akure, and he was summarily dismissed. We believe, and this is to some extent based on public disclosures, as a result of the president's displeasure in relation to that case itself. Now, political interference in agencies across the region, and particularly what we've seen in South Africa to some extent, is concerning. I think it's a worrying feature, but the new leadership within the agency have demonstrated the continued utilization of penalties, investigative techniques, and the recent one that I just mentioned is obviously demonstrative of what they're capable of achieving. So a broad range of activity, a significant amount of extraction of robust administrative penalties, and even the threat of criminal sanctions in relation to investigations. The mandate's certainly broad: competition and consumer protection, but the authority is one very much highly regarded across the continent itself.
Very interesting. Thank you, John. So you think that removal of the chairman was hopefully a one-off situation?
I certainly think it is. And I think there's a degree of, I suppose, concern that the wrong person was taken out. So Babatunde has an excellent reputation internationally. Certainly the major platforms and associations which exist, he's got a stellar reputation. I think the thinking, at least from the international perspective, and certainly practitioners who operate within Nigeria, is that it was a mistake. I think his track record speaks for itself. It really put the agency on the international map, a regional map, and as I said, was a catalyst for changing enforcement across Africa. Didn't just have the lodestar in South Africa, had Nigeria on stream, obviously with COMESA on stream. It presented a compelling picture, a complete picture across Africa. Babatunde's removal, I think, was met with massive dismay, not just, as I say, internationally, but within Nigeria. and there's a sense of regret that this was perhaps a step too far, and perhaps based on the wrong set of information, and perhaps internal lobbying which occurred within Nigeria. But I would say that it should not be a likely repeat mistake. Okay.
He was a guest on this podcast at one stage. A final question on Nigeria, John. It's a member of ECOWAS. Maybe it's early days, but are there any comments you can make about the relationship between those two regimes, ECOWAS being a supranational regime similar to COMESA, as I understand it?
Very much so. And so I think there's this approach which does occur when regional bodies come on stream, and there is to some extent a jurisdictional dispute between the priority jurisdictions within those regional bodies and the regional bodies themselves. And so what has not yet occurred, and apropos your question, Matthew, is a formal memorandum of understanding between the Nigerian FCCPC and the ECOWAS competition regulator. It's of some concern because what that means is the fundamental ethos of ECOWAS, which is to provide a one-stop shop on par with what COMESA have managed to achieve, is that to the extent that there is conceivably a notifiable transaction in ECOWAS, but equally what would constitute a mandatorily notifiable transaction in Nigeria, the current view is that that would require notification in both. And so until that's at least resolved, parties have quite conceivable filing fees to pay, but equally under two suspensory regimes, which I don't think is ideal and undermines the intent behind ECOWAS. But until that issue has been formally resolved between the regulatory bodies, I think parties are going to have to be very cautious and bear that in mind to the extent that a transaction is conceivably as a nexus and meets the thresholds for purposes of notification. It's not too dissimilar with what took place in COMESA, and we can talk about that a bit later on, where you had the disputes with, to some extent, Egypt and Kenya regarding the jurisdictional reach of COMESA itself. But I think ECOWAS, certainly from our perspective, is to be welcomed. We do appreciate regional bodies. I think they provide a good one-stop shop regime, and that's only to the benefit of global parties doing transactions which have an impact across various jurisdictions across the African continent. I think the dispute really is going to come as to the likely, I suppose, authorities' positioning. ECOWAS is still nascent. It hasn't yet established itself, as you say. And Nigeria, I think, is very much the new lodestar across Africa. And until, as I said, that issue is formally resolved, we're going to have this sort of dichotomy, which is not ideal.
Okay, good insights there, and some things for our listeners to look out for as they look at transactions. You mentioned Egypt. Let's move on to Egypt. Nicolas, could you take us through comments about how you see Egypt's priorities and recent cases and initiatives from the regulator in that jurisdiction?
Sure. The most significant recent development in Egypt is surely the introduction of the pre-closing notification regime that came online on 1st of June of last year. And since then, we have seen a significant uptake in filings, merger control filings in Egypt. Previously, there was a post-closing regime, and then for about 18 months during this transitional period, there was no mandatory regime in Egypt. But even under the post-closing regime, there was much less activity and specifically much less review from the authority. Typically, you would submit the file, they would consider whether it was complete, and then just give sign-off, except for very few outlier cases where they had a couple of questions. Now it is a full-fledged pre-closing notification regime with suspensory effect and mandatory. And so far, the authority takes an approach similar to, for example, the European Commission, where they would conduct a pre-filing review that we would go through after initial contact with the authority and presenting the transaction to them. Once they deem the filing to be complete, then they will run through would be supposed to run through the material review process under the statutory review period. However, due to the pre-filing review process, there's often a lot of questions already answered before that, and the main part on the clock is then essentially waiting for comments from third parties if there should be any, because after completeness is confirmed, there will be a publication of the notice received, or summary, of course, a non-confidential summary. And there is a 15 business days waiting period then. If no comments are received, the review process ends pretty quickly after that, due to the authority already doing quite a lot of the work in the pre-notification phase. According to the first report that we have gotten from the authority, they received just over 60 cases during the first 6 months, so reasonable amount of activity, considerable share of foreign-to-foreign transaction, and that we also see in our practice, that there are quite a lot of foreign-to-foreign transaction being notified. Outside of that, the Egyptian authority has, at least in the MENA region, been probably the most active enforcer of behavioral antitrust matters. And there we have seen a strong focus on directly consumer-facing industries, specifically food, education, and healthcare sector. There have been several cartels investigations, bid rigging investigations, as well as investigations into abuse of dominance in all three of those sectors. Although recently education and food sectors have been more pronounced. A similar industry focus we have not seen in merger control yet, which is of course not surprising, since in behavior antitrust investigations, the authority picks their investigations and their focus. Well, in merger control, they essentially have to wait to see who's coming in. And given that the new regime is only active since 9 months, there haven't been any enforcement cases, so we couldn't really speak about preferences and focus in enforcement or calling in transactions. So far, that has been the situation, but it has significantly shifted the activity of the authority. So prior to 1st of June of last year, even taking out the 18 months where there was no active merger control regime, the authority was, I'd say, in their activity about 85% behavioral enforcement. And now it difficult to say from the outside, but we're at about an even split in between their activities.
Does that mean that they have capacity issues and therefore they're having to run down a bit their behavioral enforcement, do you think?
They brought over some people from their behavioral enforcement units to the merger control part, but they've also hired quite extensively people. They attracted 2 of our associates. Also, and we understand that from other firms.
Maybe they'll come back at some point with inside knowledge.
We did hire around the same time 1 person from the authority, so they're 1 ahead, but
2 to 1.
But also they have had a very comprehensive campaign of hiring people from the universities directly. So it's not. There has been a little bit of personnel drain from the behavioral teams, but not to the point where we would see them really becoming overworked or reducing their activity, because they supplemented newly hires.
You mentioned on the antitrust side, the consumer-facing focus. Is that driven by what they want to do, or is there a government steer in that regard?
there is a government steer definitely in there. I mean, Egypt is a developing country. International pressures, inflation, the war in Ukraine that had significant effect on food prices internationally, have had a significant impact on prices in Egypt. In addition, the devaluation of the Egyptian pound has put further pressures on the population. And what you have to remember is that while from a Western perspective, the Arab Spring was often described as a democracy movement, at least in Egypt, I can't talk about Tunisia or other Middle Eastern countries where I'm not as involved. But in Egypt, a lot of it was about economic participation. Protests really ranked up when basic food stuff became very expensive, and so there is a concern of the government to keep basic staples at as far as they can at a stable price. For security concerns, but also conscious of the population just being in pressures and having needs to finance that. So there is definitely across all sectors, not just in the competition realm, a political focus on stabilizing prices in these regimes and in these sectors, and the antitrust or competition regime is one tool that they're looking at.
Right. John referred to the relationship between COMESA and Egypt, and we'll also get on to COMESA, but is there anything specific in relation to Egypt's membership of COMESA and what that relationship is like?
Today, after Kenya accepted that COMESA has priority jurisdiction and serves as a one-stop shop, Egypt is the last COMESA member country that has an active merger control regime and disputes the one-stop shop principle under COMESA. The authority has to date not explicitly declared what their position is founded in. There are several rumors out there, but they're only that. But so far, we have not seen an interest on the Egyptian side to change their position. So they will require a filing in Egypt, even if a COMESA filing is made. And as John already alluded to, the situation with Nigeria and ECOWAS, it creates obviously these issues that you have to run two procedures with two different regulators, with all of the cost and time expenditure involved, but also possibly different positions on certain issues or different
and they could, in
priorities.
theory, take different positions in relation to the same market and products.
They
right?
could.
Should be a bit strange.
They could ultimately also take a different opinion on the transaction and have one bar it and one clear it. And then we would certainly see, depending on who the parties are, but there could be litigation at that point and pressing the issue. But so far that has not materialized.
Right. I guess probably, well, Egypt sounds like the final holdout, so see how long that lasts for, I guess. Right. So, John, let's now move on to South Africa. If you could please take us through similar issues in relation to that jurisdiction.
Sure. South Africa's just come up for last year 25 years of enforcement. It remains probably the most important jurisdiction on the continent. I think it set the tone for merger control review, and equally from an enforcement perspective more generally. The simple reality is that, at least in relation to merger control, the issue of the public interest is paramount. And at large, for the benefit of these listeners, in relation to foreign-to-foreign transactions, in relation to international acquisitions, the public interest issue has caused possibly the greatest amount of headache in respect of advising international clients, and that's not likely to abate in any significant manner. The law was amended, and I'm sure a number of the listeners will be familiar with those amendments, but it broadened the ambit of the public interest factors to be taken into account. Now, generally, that expansion in relation to the public interest criteria really had a role to play in respect of major transactions in South Africa. However, at least in certain international acquisitions of domestic entities, those criteria have found their way in to be conditionally imposed. The change, obviously, in respect of the promotion of ownership of historically disadvantaged persons, that's HDPs, probably was the more contentious issue which was brought about during the amendments to our law. There are a couple of decisions which have really brought to the fore the issue of the public interest criteria and the utilization of the public interest criteria to potentially block a transaction in totality. The transaction in that regard was the Burger King deal. That was about 2 years ago. And in essence, it was the first time that the Commission had prohibited a transaction based purely on the basis that it led to a significant dilution on those public interest criteria, but predominantly in relation to the promotion of HDP, which is historically disadvantaged persons. It caused a significant uproar. The transaction was patently pro-competitive, but for the benefit of the listeners as well, it was taken on appeal and effectively resolved, but certain conditions remained. Now, apropos other global deals and international acquisitions of domestic entities, we've seen a very robust set of public interest conditions imposed, which go, certainly from an international perspective, way beyond the normal estimate of what can be expected for purposes of a merger. Now, the predominant feature in that regard, obviously, is the promotion of employee share ownership schemes, equally supply development funds, and also obligations on parties to support certain initiatives within their specific area of or sector of business. There still remains a significant concern in respect to the utilization of the public interest criteria. It is statutorily recognized. The law has been amended to bolster it. It's not going to go away. But in light of recent developments politically, in light of the status of South Africa and the international arena, there was a view that these should be watered down. And the change in government which occurred last year was, at least from a business perspective and to some extent an international community perspective, believed to occasion a bit of a change because there was a change of guard in respect of the Department of Trade, Industry and Competition's minister, and Minister Tao stepped in to take over from Minister Patel. Now, Minister Patel, for the benefit of the listeners, had largely been responsible for utilizing those public interest criteria and enforcing them in relation to merger control. Recently, the minister, that's Minister Tao, has announced the establishment of a 100 billion rand supplier fund, and that is about $5.5 billion, and stated publicly that that is going to be financed off the back of public interest conditions. So rather than the public interest criteria conceivably being watered down, I think, at least from a private bar perspective in South Africa, we don't believe that that's likely to be the case. And so, at least in relation to merger control, we've certainly seen a conceivable tick up in the utilization of the public interest conditions on foreign deals and on acquisitions by international entities of domestic companies in South Africa.
Just to be clear on that fund then, John, are you suggesting that it'll be funded by some kind of contributions from merging parties?
Correct. So indirectly, absolutely. So there'll be a portion of the condition would ultimately finance the broader fund, which is established by Parks Tao, the minister himself, which again causes some other concerns about the independence of the agency and whether or not they're being utilized for broader industrial development programs. And I'm sure the listeners are familiar with the sort of conflation between the two. Whether or not that's a right approach for purposes of attracting more international investment remains to be seen. And that really was the single biggest criticism in relation to our agencies, is that the approach under the auspices of the previous minister really made deal-making and transactional security, or brought it under the spotlight, and questioned whether or not the regime was ultimately effective in achieving that. Now, I think, apropos your question, I do believe that there are going to be more question marks in relation to the utilization of the public interest criteria, and whether or not there is more of a political agenda in seeking to extract them, which bodes, I think, to some extent, ill for purposes of international investors, and whether or not it's an attractive destination, given the time delays and equally the concerns as to whether or not those conditions are ultimately warranted in the first place. Moving on, I think the utilization of the public interest criteria have now found their way in relation to cartel enforcement, which is somewhat unique, and certainly one of the first that I'm aware of internationally, having spoken to various bodies about this issue. In a recent cartel settlement, beyond just the administrative penalty which was imposed, there were obligations on the party to the consent order to equally again promote the Supply Development Fund and to put 500 million rand towards a fund itself, which is unique. I don't think we've seen anything like that in relation to consent orders in the cartel arena. But it does demonstrate that vein or theme is certainly not abating in relation to the public interest criteria in South Africa, despite the coming on stream of the new ministry.
Wow, that's pretty interesting, and as you say, pretty unique situation so far as we're aware worldwide. Let's move on to COMESA. We've referred to it a few times. Nicolas, what does it look like at the COMESA level? Could you just maybe briefly remind the listeners, what COMESA's jurisdiction is, what it can do, and then just look at some of its priorities and the issues it's been looking at?
Yes, I mean, COMESA serves as a regional body, at least in the merger control space, and has jurisdiction over transactions that meet specific thresholds defined by the regulations, as well as have a regional impact, or potentially a regional impact, which requires that the parties have revenue in multiple COMESA member countries. Currently, the regime is voluntary, and the most significant change that will be brought with the pending amendments of the regulations is the move from a voluntary to a mandatory suspensory regime. In addition, certain other amendments will be imposed, and that brings Egypt in again, because there's of course speculation that once COMESA moves to a mandatory suspensory regime, that might maybe be incentive for Egypt to accept it as a one-stop shop, or accept the one-stop shop principle under COMESA. But so far, there has not been a confirmation of that from the authorities, so this remains speculative. Also, the amendments to the COMESA regime have been somewhat delayed. We were initially expecting them by the end of this year, the past year, sorry. We understand that they are pending and should be forthcoming shortly, but still expecting a concrete date.
Okay. And John, what about wider COMESA activity? I understand it has a behavioral element as well.
Very much so. And I think at least what we've experienced and seen is that the enforcement world within COMESA has significantly changed. I think Nicolas has touched on what we anticipate to be coming through in terms of the regulatory changes, but the authority has announced significant investigations. The one is against Coca-Cola and the other is against Yamaha, and that relates to vertical restrictions on their distribution model, and it's demonstrative of the fact that the agency is now quite evolved significantly from pure merger control to looking into conduct in the marketplace. Then recent announcements and discussions that we've had with the representatives of the agency is that they're equally going to be moving into a leniency regime, and that means cartel enforcement is going to come to the fore. I think the authority has made it a stated objective to seek to impose administrative penalties of some importance. Now, in relation to the current investigations and some of those in the past, that hasn't always been the case. I think the kind of penalties extracted under the rubric of the legislation have been limited and not significantly deterrent-oriented, which I think will change significantly in the announcements given and the views expressed publicly by the CCC or Quad C, I think now, in relation to the changes which have come through, or at least indicate to parties doing business in that area that the behavioral and engagements in the marketplace are likely to be scrutinized and ultimately enforcement activity occur.
Very interesting. I think that's a good segue to my final substantive segment here, which is, firstly, Nicolas, what do you see as the practical impact of the points we've been discussing today on your practices in international companies? I mean, it seems from what John was just saying that competition compliance across all of these jurisdictions and the COMESA jurisdictions might be an example of that.
Yes, Africa has been developing quite significantly, both in the merger control as well as in the behavioral space. It's become much more of a realistic threat to non-compliant entities if you look at enforcement activity. And parties, not just African parties, but also foreign parties doing business in Africa or having a nexus to Africa will have to much more diligently have to consider African regimes, whether those be national or regional. And with what we've seen in ECOWAS, them somewhat following COMESA and establishing a regional regime initially, and we've seen that in the history of COMESA also, these have added additional complexity, which obviously makes transactions much more difficult, and also when it gets into the behavioral space, might put further challenges to parties. The goal, obviously, of these regional regimes is to limit the complexity a little bit, and especially in larger mergers or potentially larger investigations into behavioral violations, concentrate the procedures with one regional or multiple regional across Africa regulators. But this resistance to that we've still have residual parts of in COMESA and starting off in ECOWAS currently adds a lot of complexity. And a little bit from my side, and I'm not sure how much that affects you, John, but Egypt coming from the point of low activity to now significant activity, but also being a development country, it seems that in some transactions for parties, it is still an afterthought. And that often causes them to file late and concentrate on other jurisdictions first, which then causes Egypt to be a timing item, which it maybe didn't have to be. So rethinking of parties on that regard and doing a more diligent initial analysis also on timelines and what can be done with, for example, early engagement would help.
Good advice there, I'm sure. John, so what about you? Some practical points. Obviously, you mentioned South Africa and these public interest on both the merger control and cartel side as an outlier, but what do you see some general further final thoughts on practical impact on your practice?
I think we've grown with African regulatory expansion, quite frankly, as a practice, and it's undoubtedly a series of jurisdictions which can't be ignored. I think to echo what Nicolas has said, in the formative years of the practice, a large amount of advice sought was how to avoid engaging with the regulatory agencies, unfortunately. And that was a sort of clarion call from a number of international parties and firms. It's changed significantly. I think the simple reality is that these agencies are probably demonstrating their capacity and ability internationally. It's no longer just a case of within the continent itself. Certainly, COMESA is considered highly internationally on the sort of speaking circuit amongst all these platforms, and equally here at the ABA. So it's no longer a case of avoiding the regulatory scrutiny. It's a case of complying with the regulatory scrutiny and dealing with it in the best way possible. The agencies that we act for are hugely receptive, and I think there's every opportunity to interact with them. They are now well placed and experienced enough to be able to understand the complexity of international deals. They've had a number filed before them, and equally, I think the rapport with the private bar like ourselves is hugely advantageous. So I think, at least in sort of a short synopsis of all of that, is these regimes cannot be ignored, and I think compliance is vital, not just from a merger control perspective, but more importantly from an enforcement perspective. The stated objective publicly by most of them across the continent is that there's a move beyond pure merger control assessments or review into the realm of cartels, dominance issues, and vertical restraints. So that means that you have to at least have your house in order across all the regional bodies themselves, but more importantly against some of the established jurisdictions.
Well, thank you very much. I think we've learned a lot today. Before we finish, we like to ask some personal questions on our Curious Amalgam. So I'm going to ask you, Nicolas, first. Could you please tell us something interesting or unusual about yourself that we wouldn't know from just working with you professionally?
Yeah, I knew the question was coming because last time I was talking about my passion for snow in living in the Middle East.
Right. Maybe that's something new.
Yeah. No, I was thinking about something new to disclose. Well, my private life, which is not the easiest thing for a lawyer, since we're... I do have, aside from my work, and that might, like a lot of people who work with me might not really expect that, but I used to have a little bit of an artistic part. What my criminal law professor later would call those years where men become hombres and commit certain violations that they wouldn't otherwise in a more senior part of their life, was a graffiti artist. Not anything grand, and never close to something like Banksy, of course. More of sort of a 14-year-old little boy running around. But that
with your spray can.
With my spray can.
All right. Well, that's an interesting one. What about you, John?
Well, what most listeners or professional briefers wouldn't know is my formative years are spent in the US. So I've got a good affinity, having spent a number of years working here and engaging with the US. I suppose a lot of respect and attention paid to the jurisdiction. So
you attended elementary or junior high, or
elementary? Yeah.
Okay. So, very interesting. And finally, what's the most memorable thing or one item you've identified at the spring meeting this year of interest, Nicolas?
I think that the mood is quite resilient, given where we are right now and what's happening globally. Regulators from the US not attending. There seems to be, I was not, or I was worried that the mood, especially with also the US administration going against law firms, being a little bit more bleak, but it seems that has not phased the community yet, and that the community is resilient, which, if that translates to other aspects and to our work, I think is a promising sign.
Absolutely. And what about you, John?
I think the broad attendance, and particularly from our reach and focus, the attendance of a number of new African regulators, that's certainly something to be lauded and welcomed. And the exposure to the sections, the exposure to the participants here has certainly been noteworthy, and a lot to be learned from their perspective, and hopefully transferred back to competition enforcement on the continent. And that's something I've noticed. It's not limited to South Africa, for example, or COMESA. It's far broader than that, and that's something which I welcome, and it's largely to the initiatives of the ABA.
Absolutely. Well, thank you very much, John and Nicholas, and thank you everyone for listening to this episode of Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.